Hello, I'm Captain Jillian Kaido, a disability attorney with the Office of Disability Counsel, often referred to as the ODC. Our mission here at the ODC is to deliver prompt, professional, independent legal counsel to fit, ready warriors determined to return to the mission, or to assist those warriors who are injured and wounded air and space professionals facing medical separation from military service. That means we represent you and you alone. You may have recently processed through the Disability Evaluation System, commonly referred to as the DES, and found that the results fell short of your expectations. Due to recent changes in the DES process, the formal Physical Evaluation Board is the last available option for review and appeal prior to being separated or retired from service. Today, we want to briefly provide you with some information on the Board of Correction of Military Records, also known as the BCMR. The BCMR has the ability to review your case and change the outcome, but it's not part of the DES and likely will not rule on your case until after you leave active duty. The BCMR is governed by Air Force Instruction 36-2603, Air Force Board for Correction of Military Records.
Hello, I'm Captain Brian Noble, also a disability counsel with the ODC. The Secretary of a military department, acting through a BCMR, has authority to change any military record, when necessary, to correct an error or remove an injustice. Within the Air Force, by law, the BCMR is the highest level of administrative review. Therefore, you must first exhaust all available administrative avenues of relief before applying to the BCMR. Otherwise, the board may deny the case on that basis. If you are going through the DES and you do not agree with the outcome of the informal board, at a minimum, you will have to appeal to the formal Physical Evaluation Board or file a Department of Veterans Affairs Rating Reconsideration appeal to be eligible to apply to the BCMR. If you do not agree with the final outcome of the formal board, you should be eligible to file a claim to the BCMR.
The BCMR bases its decision on the written evidence contained in the case file. The case file consists of military records, an advisory from the Office of Primary Responsibility, and statements, arguments, and documents that you provide for review. The burden of proof of either error or injustice rests with you, so it is in your best interest to ensure that you collect all your records upon separation and provide a thorough and comprehensive application to the BCMR. The BCMR's decision is final and conclusive.
The BCMR process flows as follows. First, you must initiate the process by using the prescribed forms and fully documenting your case. After initiation, the BCMR will decide whether to hold a hearing or not. If there is no hearing, the BCMR will review all the available materials and make a decision or forward the case to SECAF or his or her delegee. If the BCMR elects to hold a hearing, they will conduct the hearing, which you can participate in, and then review the case and make a decision or forward to the appropriate decision maker. This process is broken down more specifically as follows.
To initiate the BCMR review, you must fill out a DD Form 149, Application for Correction of Military Record. At a minimum, you must provide the name under which you served, your Social Security number or Air Force service number, your current mailing address, the specific records correction being requested, proof of proper interest if requesting correction of another person's records, and your original signature. Please ensure you use the December 2019 version as the address has changed. To ensure your application is received and processed in a timely manner, mail the DD Form 149 to the address on the back, along with any source documents, or send by email to the address displayed below. However, please note that you should not send personally identifiable information, also known as PII, or personal health information, also called PHI, from your commercial email address like Gmail or iCloud.
If your contention involves a medical issue, you will also need to fill out a consent form to release your medical records from the VA. This is a VA Form 10-5345, request for and authorization to release medical records or health information. Sign and attach it to the DD Form 149. Please review the release document to ensure you understand what you are consenting to. If the former airman is deceased or incompetent, the surviving spouse, former spouse, next of kin, or a legal representative may apply with supporting documentation such as a power of attorney, marriage license, or death certificate, indicating they have proper legal standing to apply to the BCMR.
You can find these forms on ODC's Facebook page or e-publishing. You can find ODC's Facebook page using the QR code on the screen or by searching ODC in Facebook. You do not need to have a personal Facebook account in order to find and access ODC's Facebook page. Before applying, you should consider 1. Reviewing Air Force Pamphlet 36-2607, which is also available on ODC's Facebook page. 2. Discussing your concerns with MPF, your finance office, or other appropriate officials. Errors can often be corrected administratively without resorting to the BCMR. And 3. Ensure you have exhausted any and all remaining administrative remedies. Otherwise, the board may return the request without considering it.
Ordinarily, you must file an application within 3 years after the error or injustice was discovered, or, with due diligence, should have been discovered. In accordance with federal law, time on active duty is not included in the 3-year period. An application filed later is untimely and may be denied by the board on that basis. The board may excuse untimely filing in the interest of justice. If the application is filed late, you should explain why it would be in the interest of justice for the board to waive the time limits.
Please note, applying to the BCMR does not stop other proceedings. If the Physical Evaluation Board has decided that you will be discharged or retired, applying to the BCMR will not prevent or delay that from happening. The BCMR only has authority to correct the record and result of the Physical Evaluation Board.
You may be represented by counsel at your own expense. The term counsel includes members in good standing of the bar of any state, but is not only limited to attorneys. Counsel at the BCMR includes accredited representatives of veterans organizations and other persons determined by the executive director of the board to be competent to represent your interests. Please note, attorneys at the ODC are not able to represent you at the BCMR.
Briefs or narratives in support of applications may not exceed 25 double-spaced typewritten pages. Must be typed on one side of a page only with not more than 12 characters per inch, and must be assembled in a manner that permits easy reproduction. These limitations do not apply to supporting documentary evidence, for example, attachments to your briefs such as medical or personnel records. In complex cases and upon request, the executive director of the board may waive these limitations. You may withdraw an application at any time before the board's decision, but note that withdrawing your application does not stop your 3-year time limit to file.
The burden of proving the error or injustice rests with you, so make sure you submit all relevant evidence, arguments, and attachments. In addition to the information you submit, the BCMR may get additional information and advisory opinions on an application from any Air Force organization or official and may ask you to furnish additional information. You should be given an opportunity to review and comment on advisory opinions and additional information obtained by the BCMR.
A panel consisting of at least 3 board members considers each application. One panel member serves as its chair. The panel may decide the case in executive session or authorize a hearing. Normally, only members of the BCMR and staff will be present during deliberations. Only the BCMR may determine if a hearing is necessary, meaning you do not have the right to a hearing.
If you are afforded the opportunity to be present at a hearing, the executive director will notify you or your counsel of the time and place of the hearing at least 30 days in advance. If you decline or do not attend the hearing, the BCMR will decide the case in executive session. If you accept, you should also include information regarding whether your counsel will appear and whether you will present any witnesses. At the hearing, you may appear before the board with or without counsel and may present witnesses. It is your responsibility to notify witnesses, arrange for their attendance at the hearing, and pay any associated costs. The panel chair conducts the hearing, maintains order, and ensures you receive a full and fair opportunity to be heard. Formal rules of evidence do not apply, but the BCMR observes reasonable bounds of competency, relevancy, and materiality. Witnesses will not be present except when testifying and must testify under oath. Hearings are recorded verbatim and are normally limited to 2 hours, but the time limit may be waived to ensure a full and fair hearing.
The board will not deny or recommend denial of an application on the sole ground that the issue has already been decided by the Secretary of the Air Force, Secretary of Defense, or the President of the United States in another proceeding. The panel's majority vote constitutes the action of the board. The board will make determinations on the following issues in writing. First, the BCMR determines whether there are allegations of retaliation or reprisal related to your case. If so, there is a special process prescribed by law the BCMR must follow. This video is focused on cases involving unfairness or errors in the DES, and therefore will not go into that process. Second, the BCMR will rule on whether the application was timely. In other words, the BCMR will determine the application was filed within the 3-year window or if it's outside the window, and whether it is in the interest of justice to excuse an untimely filing. When the board determines that an application is not timely and does not excuse its untimeliness, the application will be denied on that basis.
Third, the BCMR will ensure you exhausted all other administrative remedies. As stated earlier, in the case of the Disability Evaluation System, the BCMR will determine if your case has progressed beyond the formal physical evaluation board phase and, if applicable, the Department of Veteran Affairs rating reconsideration phase. If you have not progressed beyond these points, the application will be denied on that basis. Finally, the BCMR will rule on the merits of your case. Put simply, the BCMR will determine whether you have demonstrated the existence of a material error or injustice that can be remedied effectively through correction of your military record, and if so, what corrections are needed to provide full and effective relief.
For cases involving unfairness or errors within the DES, the BCMR acts on behalf of SECAF and its decision is final when it denies any application or grants any relief. The board is able to grant relief when 1. The relief was recommended by the official preparing the advisory opinion, 2. The decision was unanimously agreed to by the panel, and 3. Such a decision has not been withheld by SECAF. If these 3 elements are not met, the BCMR will send the record of proceedings on to SECAF or her designee for final decision. The Secretary may direct such action as she deems appropriate on each case, including returning the case to the BCMR for further consideration. Cases returned to the board for further reconsideration will have a brief statement of the reasons for such action. If the Secretary does not accept the board's recommendation, the Secretary's decision will be in writing and will include a brief statement of the grounds for his or her final decision. Additionally, the BCMR may identify DoD or Air Force policies, instructions, guidance, or practices that are causing unsound business decisions, unfair results, wastes of government funds, or public criticism to the appropriate office for review and resolution.
After the decision of the BCMR, all your administrative review options have been exercised. If you still believe your case was decided incorrectly, you may be able to file in federal court. In this case, you must employ private legal counsel to review and work your case.
This concludes ODC's brief overview of the BCMR and what to expect should you request review of your case at the BCMR. We hope this video has been informative. Please take special note, nothing in this video constitutes legal advice, and you should not make any decisions based solely on the information in this video. Additionally, attorneys within the ODC are not able to help you with a BCMR application. For complete guidance on the BCMR process, please refer to AFI 36-2603 or to the AFPC website, as they will have the most current and to-date guidance and requirements. You can also find frequently asked questions at the QR code below.